is oral argument in our case number CV 180546, Sims v. Sims. Counsel, each of you will have 20 minutes to make your argument, and the appellant can reserve time for rebuttal. I would just ask that you do that yourself. We should have a clock on the screen. Does everybody see a clock? I don't. Do you see anybody?
No, Your Honor.
Okay. Oh, there we go. Now do you see one?
Yes, Your Honor.
Okay. So I would ask the appellant, if you want to reserve time, keep that track yourself with that clock. Also, this is being recorded, so I would ask that you state your name and the name of your client at the outset of your argument. We have read the briefs, conferenced the case, and we're ready to go. So let's begin with the appellant.
Good morning, Your Honor. This is Jim Torrey for TP Racing, Jerry Sims, and Bell Racing, and Michael Manning is with me. Your Honor, did you want us to address first the 41-1092.03 issue, or just go into our argument?
Yeah, you know, I'm hoping that you have an easy answer, that it's not relevant or important, and if you want to get to that right away, that would be sure, that would be helpful.
Okay, I'll do that then. And you're right, Your Honor, it is irrelevant. And just taking a step back, if you look at 41-1002, which talks about these rules, it mentions that this chapter creates only procedural rights and imposes only procedural duties. They're in addition to those created and imposed by other statutes. So this is just creating an absolute baseline floor for procedural rights. It doesn't create any jurisdictional limitations. And then C is even more informative. It says an agency may grant procedural rights to persons in addition to those conferred by this chapter, so long as rights conferred on other persons by any provision of law are not substantially prejudiced. And that's what we have here. The Racing Commission created a different rule.
You said 40, is that 41-1002C that provides that?
Correct. Yes, Your Honor. And so that's what we have here. We have the Racing Commission created a rule that allowed for appeals by anyone who is a person aggrieved. And in any event, you can tell that 41-1092.03B is not relevant to us as well, because it's also discussing a different part of the process. I mean, our situation is a little different in that we have a dual level agency. So not all the provisions of 41-1092 apply to the commission appeal. So 41-
Counsel, doesn't the Enabling Act for the Racing Commission reference, I think it's within ETSEC, but certainly embrace this very statute?
It references...
Go ahead.
I'm sorry, Your Honor. It references, yes, 41-1092, but what it's referring to is 41-1092.08 C and F. Those are the only parts that relate to the commission proceeding. What we have here is a dual level.
Counsel, let me interrupt you. Where are you getting that authority that it's limited to those sections? The statute I'm reading here says Title 41, Chapter 6, Article 10, which is entitled all of 41-1092.
Well, two things, Your Honor. One, it wouldn't make any sense to apply all of these provisions to a commission proceeding. Let me give you an example. 41-1092.
It doesn't apply it. It says the commission may hear an appeal in connection with that. So it would seem that everything related to an appeal would then apply.
You're talking about 1092.03?
Now I'm talking about 5-104D, which says the commission may hear an appeal of a decision of the director in accordance with Title 41, Chapter 6, Article 10, which is 41, 1092, etc.
Correct, and that is referring to 41-1092.08 C and F, which are the parts.
That's what I'm getting at. You keep saying that's referring to 4108 C and F, but where's your authority that it's only referring to those two subsections?
Because 41-1092, if you go through it, not all of it, it just is a matter of logic. And let me just explain what I mean. 41-1092.03A, okay, that's talking about the notice of denial. Then you get to B, and that's talking when you have the initial appeal to a hearing officer of the notice of denial. And you can see at the bottom of B, it says the agency shall notify the office of the appeal, a request for a hearing, and the office shall schedule an appeal or contested case hearing pursuant to the rules. Well, this is talking about a referral to OA. Okay, that's what happens after you have the initial notice of denial. That's not talking about when you have an appeal to the commission. And it's the same thing. If you look at 41-1092.07, it's talking about the hearing before the Office of Administrative Hearings. There's multiple references to the administrative law judge. That's not talking about a situation where you have a dual level agency, and we've already gone through the OA process. And now you've
Counsel, aren't you asking us to interpret a law that says the commission may hear an appeal as provided in this entire subsection to say not as provided as this entire subsection? You need some authority to tell me that it's limited to those two subsections, or you've lost me.
Especially I don't know how you expect us to wield logic to overcome English. If you could give us the authority, that'd be great.
Okay, well, B also 5-104B said the director is subject to ongoing supervision by the commission, and the commission may approve or reject decisions of the director in accordance with rules established by the commission. And 41-1002C says they can create procedural rules as long as they're broader than the rules created in the Administrative Procedures Act. C is plain on that. It says an agency may grant procedural rights to persons in addition to those conferred by this chapter. And
does he use the word prejudice?
It says so long as rights conferred on other persons by any provision of law are not substantially prejudiced. And I'm not sure how allowing people broader appeal rights would prejudice anyone under the law. There's no law that says people are not subject to scrutiny in a heavily regulated gaming industry. In fact, the law is just the opposite.
And so when you say, so you read that as not preserving a minimum procedural requirement, almost the inverse, that you can open the door. It's something that is discretionary, and as long as it doesn't prejudice, but you're saying here it wouldn't prejudice anyone, because why? Because what about your colleague's client? Might it prejudice him?
I can't see how it would prejudice him. He's never argued that. He's never actually even mentioned this section because I don't think he even believes it applies. But no, I mean, look, we're in a gambling industry. All the law is unanimous that people are heavily regulated. When you apply for a license, you're opening yourself up to heavy scrutiny. There's no law that says that you should be limited to minimum scrutiny, and that's what C refers to. There has to be a provision of law that says that protects you that's diminished by this. So look, between C and everything else, it says they can create broader appeal rights, broader procedural rights, which they've done here. It's not a limitation on their jurisdiction.
I want to touch on that just a little bit. So you say in C that says an agency may grant procedural rights to persons in addition to those conferred by the statute. Is the right to appeal when you aren't part of the underlying proceeding, is that a procedural right or is that a substantive right?
I would think it would be a procedural right, Your Honor, because it's established by the procedural rules.
And I just want to note for the record, Judge Perkins, although her video is not working, she is able to hear and is participating in the argument. And I think if she wants to ask something, she will be able to speak up.
Ms. Alarcon might want to add some more to this. I'm not sure. I think she has some ideas on this as well, but that's our position, at least on that issue.
So your position is that earlier statute that allows for a broadening, I think subsection C you said, with that prejudice kicker. Any other authority as to why this matters or doesn't matter?
Right. B and C define what the later statute means.
What, counsel?
B and C of 41-1002.
Okay.
They're telling us what that later statute is, and that later statute is just a procedural floor that can be expanded.
If that's all you have on that, move forward.
Let me ask you that. I don't see a cross-reference specifically in 5104 to 41-1002. I do see a specific cross-reference to 41-1092. So why do we care as much about what 41-1002 says?
Well, it's a statute of general applicability to the entire Administrative Procedures Act. It defines what those other statutes are and what they mean.
So general statute then would apply more than
actually points
cross-referenced in the 5104.
Well, yeah, 41-1002 is defining and telling you what 41-1092.03 and all those other portions of the Administrative Procedures Act are.
All right, let me ask you a general question too. In 5104D, it says any person adversely affected by a decision. We have case law that goes all the way back to the 30s and 40s that deals with what adversely affected means. And that case law has generally said that that is the person whose rights were determined, whose license was denied. And I'm specifically referencing Ernst v. Superior Court and Beach v. Superior Court. Why isn't that a limiting power on who may appeal a commission decision or appeal a decision to the commission?
That, again, is we've got a dual level agency here, and that is referring to the initial appeal of the notice of denial. So if you go through that, you've got any person adversely affected, that's what you're talking about. By a decision of the steward or by any other decision of the division, so that's the director's decision, the notice of denial, you can request a hearing. That's saying, I want to go to OA and challenge things. Then we go to the next step. It says the decision of the administrative law judge becomes the decision of the director unless rejected or modified by the director within 30 days. So that's after we get the ALJ decision. Okay. Now we have the director decision. Then we go to the last step, and that's subject to a different standard.
And that's the one that says the commission may hear an appeal as provided in 41-1092.
Correct.
And your position is 41-1092 is not a limiting power because the commission has expanded its authority?
Yes.
Pursuant to 41-102C.
Correct. And again, I think that C, it's just a floor, and that's talking about that same hearing phase too. If you read all the way through B.
So, Mr. Torrey, this is the first time I've heard your argument, so I'm just sort of thinking it through. But if that's the case, that we have this earlier 41-102, which says all bets are off, and that it really doesn't matter what it says in the enabling statute, you can always, broaden was the word you used? Doesn't that, leave a good, 40, 100 pages of this book in front of me toothless or meaningless or unenforceable, or I don't know, whatever adjective you want to throw on there, but it just seems to what is it, aspirational, these enabling acts? And
No, Your Honor, not at all. 41-1002C, I mean, it says what it says. And beyond that, this is just creating a floor of rights, saying these, at least you, as an agency, you can't prevent these people from filing an appeal in this situation. These are the minimal procedural rights, but you can add to those rights.
Aren't there more rights than just the people you're talking about? What about the person who's seeking the license? Doesn't that person have rights? And if you're talking to me about how we're going to interpret the procedural requirements, are those rights irrelevant? Or because there, if we use that adjective you're talking about, broadening rights, it would have the inverse impact, wouldn't it?
Well, no, Your Honor, it increases everybody's rights, and also the statute is plain that there has to be a right conferred by a provision of law. And as I said before, there's no right this is an exercise of the police powers of the state. There's no right to be free from scrutiny. This is a highly scrutinized. That's why we have two layers. We have a director and a commission. It's one of the very few agencies, and it was expressly set up that way so that there would be extra scrutiny on people.
So let me ask you. Let's say the commission said that. So I was an antitrust lawyer when I was a lawyer. Let's say the commission said competitors may freely challenge licensing of the whoever the central or main other competitor is, and so, but they wouldn't fall necessarily in the class of plaintiffs identified in the enabling statute. And is that something that the commission could have authority to do? Just pretty much expand it to every corner of society, the pool of potential challengers?
Yeah, I think so. There's unlimited review of the commission. I mean, if you look at it's 5104B says that they can review and change any decision of the director with no limitations. It's plain that they were trying to get broad power. And look, this is up to the commission.
Why the cross-reference to 41-1092? Why even include that if it's just intended to give the commission broad power to set its own rules?
They were referring, I think, to 41-1092C and F, which talk about the commission's authority to, talk about when you have a commission that's appointed by the governor, they can then do that. Again, 41-1092.07 plainly does not apply to the commission proceeding. And a lot of these provisions don't, because it's talking about ALJs. There's no ALJ at the commission. You don't go back to the ALJ if there's an appeal to the commission. It just...
Where does it say? Let me pull it up. ALJ. It's just saying.
But you would agree that 41-1092.03B does reference appeals. So your argument that some sections may not apply would be true, but I don't see how you see that 03B doesn't apply.
Well, Your Honor, two things. It talks about appeals, but this is talking about appealing the notice of denial, the initial stage. Okay, it's talking about you appeal from the notice prescribed in subsection A. That's what this is talking about.
This is, what are you referring to?
I'm sorry, 41-1092.03B. That's what this provision, and even if you look at the last sentence of 41-1092.03B, again, it says, when you get one of these appeals, the agency shall notify the office, that's the Office of Administrative Hearings, of the appeal or request for a hearing, and the office shall schedule an appeal. This is talking about the ALJ stage. When you've got the notice of denial, then the license applicant
says may obtain a hearing on an appealable agency action or contested case. It's much broader than just the ALJ stage.
I disagree, Your Honor, when you read the whole thing, but in any event, even if this applied, this sets a floor. This is the minimal number of people who can appeal. It does not set the ceiling, and 41-1002C makes that very clear, and B.
I assume you'll want some of your time for rebuttal. We've only got a minute 41 left, so.
Yes, Your Honor.
Okay, thank you, Mr. Torre. Let's go to Mr. Tillerman.
Good morning, Your Honors. Confirming you can hear me okay?
I can, thank you.
Fine.
Thank you. And I'm here with my partner, Paul Charlton. Your Honors, in response to the specific question that has been raised with the appellants, Section 5-104D says in the last sentence that the Commission may hear an appeal of a decision of the Director in accordance with Title 41, Chapter 6, Article 10, with no limitation somehow excluding 1092.03. I would just note that previously in its filings before the Commission and with the Court, the Commission and the Jerry parties have argued that reference to Title 41, Chapter 6, Article 10 references all the provisions from 1092 to 1092.12, including subsection 1092.03B.
Mr. Tillerman, let me first ask you a pretty general question. That is, your colleague had said you wouldn't even interpret the statute that we've raised, sua sponte, to have any significance. Is that your position?
Thank you, Your Honor. Absolutely not. We think that the plain language of 5-104D in the last sentence incorporates this provision specifically that the Court has asked about. And of course, in Section 1092.03B, the appeal rights from an appealable agency action are simply and given only to parties. And we filed with the Court the Paloma Irrigation and Drainage District, which cited the Ernst and the Beach precedent for exactly that proposition.
But isn't there also a statute that explains a commission with members appointed by the governor is qualitatively different in that it has greater authority and the authority to revisit a director's decision whenever it wants?
Thank you, Your Honor. We would argue that is not the case. Under 41-1092.08C, it says that the commission, whose members are appointed by the governor, may review the decision of an agency head as provided by law. And we would very much submit that the subsection, three subsections earlier, is the law. And from an appealable agency action, the only parties that are allowed to appeal are parties either who have been named as parties or a party who will be adversely affected by the appealable agency action and who exercised any right provided by law to comment on the action being appealed or contested, then provided that the grounds for the notice of appeal or request for a hearing are limited to issues raised in that party's comments. That subsection and that legal requirement is incorporated into 5-104D with appeals from the commission, and it makes perfect sense. I would just add that under Mr. Torrey's citation to 10002 subsection C, it says that an agency may grant procedural rights to persons in addition to those conferred by this chapter, so long as rights conferred on other parties by any provision of law are not substantially prejudiced. And Your Honors, when Ron Sims has gone through a 22-day trial and has given testimony to an ALJ face-to-face, and then the director, after reading the ALJ's decision, has said he agrees 100% with the findings of fact and conclusions of law, it significantly prejudices Mr. Ron Sims if the Jerry parties can then be allowed to parachute in and say we're persons agreed under the commission's rule.
Well, so let's.
I'm sorry. Go ahead, Judge White.
Okay, so we have two parts to this 41-1092.03. We have this what I was calling the adjective of what is it? Adversely affected, I guess, adverb. And then we have the second component of commenting and actual participation in the earlier stage. So let's focus on that first, adversely affected. Is that in any way different than person aggrieved as set forth under the administrative regulation?
Your Honor, I would say that a party adversely affected by the appealable agency action is defined generally as the party. And that's, we think, how the statute should be construed. Party is defined in Chapter 41 as someone who is admitted as a party or properly seeking and entitled as of right to be admitted as a party.
So I guess your argument then would be the administrative regulation that uses those two words, person aggrieved, is not even worth the paper, well, I guess in today's age, is worthless. It has no meaning.
Not necessarily, Your Honor. That's the statute that governs the rules. If there's a conflict, the statute governs. And the appeal...
So the answer is yes.
No, I think it does have meaning, Your Honor. I think that it's been generally interpreted to be a party whose rights have been aggrieved, the aggrieved person.
Okay, so you're saying that the administrative regulation almost incorporates this subsection B, which is this two-part. Okay, and the second element, the comment element.
Judge Weinzweig, I've lost video on Mr. Tillman. Are you still there?
I can see him. Can we stop the clock? And
I can't hear him either.
Judge Morse, this is Mr. Tillman. I just haven't said anything.
Oh, okay. All right. Now I see you. Okay, go ahead. I'm sorry.
Thank you.
Okay. There we go. So, and then we have this this comment element. What does that entail? Could Jerry just pick up the telephone and say, listen, this is something I'm concerned about, and then if we were to interpret Jerry and the partnership as falling under that descriptive term, I understand what you're saying about party, but adversely affected, would that be sufficient for purposes of what a comment is required or participation?
Your Honor, the statute defines a party as someone who is admitted or properly seeking and entitled as of right to be admitted as a party. And so if there's someone who would like to comment on Ron Sin's license application, they have every opportunity to seek to become a party properly seeking and entitled to be as of right to be admitted as a party. And if that's not the case, then they're not entitled to go and ghostwrite the decision of the director or meet Mr. Sims in the dining room where there are no cameras. Those are not comments. Those are ex parte communications.
So at this point, your argument is less that Jerry and the partnership can't be or couldn't have even appealed. It's just if they were going to do so, they had to formally, I don't know if this is the right word, but intervene at that earlier stage, because you would agree with me, the statute plainly anticipates someone above and beyond a licensee. Would you agree with that?
It's absolutely what party is defined as, someone who's properly seeking and entitled as of right to be admitted as a party. And Judge Weinzweig, I don't want to suggest that we are saying that the Jerry Sims party are somehow persons aggrieved. We think that the things that they're challenging from below are, number one, partnership issues. And Judge Bergen said very clearly that this rule is not meant to litigate the inner workings of a partnership. They should go to the partnership statute. And the second thing is that this is reputational injuries. They say that the commission, that the ALJ said bad things about us in his ruling. There's a couple of issues with that, Your Honors. First is the director found those ex parte findings to be absolutely accurate, and so did the commission. And the ex parte influence that now the commission is joining the Jerry parties and arguing that they've been falsely accused of things, the commission adopted those communications, the ex parte rulings of the ALJ, paragraphs 49 through 56, in their entirety, and Mr. Sims did not appeal. Now they can't come and saying the bad things the ALJ said and the director accepted and the commission accepted and that we are not appealing somehow allow us to be aggrieved persons. Judge Burke.
Counsel, I want to, if I can, before we move forward off of the 1092 at 03, I reviewed your briefs and a major portion of the record below. I don't see that you raised this argument at all. Why should we allow this argument to carry the day now that 41-1092-03B limits the Jerry Party's ability to appeal?
Judge Morse, thank you. Of course, the panel can affirm for any reason under the law based on the facts of the case, including the statute that the panel brought to our attention, which we think does apply and it does limit the appeal to parties. We think that the fact it hasn't been discussed in the briefs below is not dispositive on whether this court can raise that as an issue and rule as it being dispositive in the case.
Are there factual issues that we can't address? For example, whether or not the Jerry Parties attempted to or did participate and provide comment below to the extent that would be applicable?
Your Honor, I think the record is clear that they never did try to intervene. They could have before the ALJ or after the director made his decision. So I don't think there are any facts at issue about whether they are a party, someone who has been admitted or sought to be admitted and entitled to a right. Your Honor.
Did they? Well, that's if you interpret it as they had to move to intervene. But I think the statute says exercised any right provided by law to comment on the action being appealed. So would that entail looking at the record to determine whether they even sent letter or provided evidence or provided a statement of position below?
Your Honor, the record is clear. I don't think there are any factual issues. They did not move to make a comment after the director denied Ron's license. They did write the opinion, ghostwrite it, but they never commented on it. Or at the ALJ proceedings, they could have and moved to intervene as a party that had a right, saying this is going to affect our license.
You keep saying intervene, and I'll hold you to the same standard I held the other counsel. You keep saying intervene, but that's not what the statute says. The statute says comment. Any right provided by law to comment on an action being appealed or contested.
Exercised.
If they provided a draft decision, couldn't that be interpreted as a comment on the decision below?
Your Honor, we do not believe that someone can ghostwrite a director's decision without telling Mr. Sims that this has happened, Mr. Ron Sims, and allowed to be considered to be a comment under the statute. A comment would be where someone seeks as of right to become a party, however you want to say that. It is that someone who is properly seeking and entitled as of right to be admitted as a party.
Why is party just defined retroactively? Is there any prospective meaning we could glean? Certainly today they're a party. And so where is the time limiting factor on that word?
It's incorporated into Section 5104D, Your Honor, which says in order to have an appeal, they would have had to comply with the statute. I'll just note in terms of what's been presented below that the Jerry parties in their notice of appeal to the commission said that if the commission wanted to limit appeals to parties, it would have used the word parties in the rule, thus limiting appeals to parties, but it chose a broader rule.
Where is that argument?
Your Honor, it's found in their notice of appeal to the commission.
Okay, that's fine. I'll find it.
It's attached as tab 7 to their opening brief.
Okay. All right. Keep going. I'm sorry.
No, I think that summarizes our position that they can't, after the final director decision, at that point seek to say we are a party or should be a party at this point. Your Honors, if there's any other questions, I'll move on to some other parts of our argument.
Please do.
Your Honors, we would say that this case is about forum shopping. That Jerry clearly, as the court noticed in the Paloma Irrigation and Drainage District, there are plenty of remedies If we want to go to persons aggrieved, there are plenty of remedies, and what he should have done is gone to a court of law, where, of course, there would have been due process and judicial ethics. Judge Bergen said context matters, and she noted that these rules are not meant to litigate the types of issues that the Jerry parties are bringing before the commission. We would argue without, they say, any due process for Ron and without any judicial ethics. They say that that's fine, and Jerry's...
Context matters. I read that as not helping your client, because when I think of context, I think of market context, and I think of the need or absence of need for greater regulation. And so if you read the Supreme Court case, Mendelsohn from the 1950s, it explains that same point, which is context matters, and contextually, we want to hear from more folks about possible problems with regard to liquor than maybe haircutting or barbers. And so let's move on back again. I would think you'd also say we want to hear from more people about gaming than fill in the blank, masseuse. We it seems like we license everything. So when you say context is helpful, how is it helpful? Isn't it the context of the market being regulated?
Thank you, Your Honor. Mendelsohn was specifically addressing the rights of a neighborhood, people where the liquor store would be placed in their backyard, and it said clearly someone who can have a right to contest having a liquor store in their neighborhood, as well as someone seeking an application. We think that that would be similar on a person aggrieved under this statute. But what the statute doesn't provide is for alleged reputational injury on findings of fact that have been accepted all the way through the commission, and then also partnership issues, which should be raised in a court of law.
Counsel, is it reputational? It seems to me there's a pecuniary angle here. You might want to talk about whatever the effective, the causation, but the ramifications, at least that your colleague is arguing, are far more than reputational. They're pocketbook.
Your Honor, there's been absolutely no evidence to suggest that Ron Sims being licensed and approved after a 22-day trial and a director accepting the findings of fact and conclusions of law have had any negative impact on the Jerry parties. As a matter of fact, what's happening here, which is very problematic to us, is that the commission accepted those ex parte influence findings of fact and incorporated it into its decision. But now, on appeal, the commission is joining the Jerry parties in saying that the director decision, this is on page 36 of their opening brief, the director decision makes findings specifically about TP Racing and Jerry that are false and objectionable. Your Honor, they accepted those facts as being accurate under the entire record, and now Ron Sims is litigating against the commission, who's saying our findings of fact regarding the ex parte influence are false and objectionable. Judge Bergen caught this one, we think, got this one exactly right, where she said those ex parte influence are simply stating facts that no one has contested, and the Jerry parties haven't appealed. That's not, now we can't come on appeal and saying these uncontested findings of fact that the commission adopted, somehow the commission is allowed to argue that they're false and objectionable regarding Jerry. We would argue, Judge, that it's speculative under the Scottsdale case. Arguing about how it might impact their license in the future is not sufficient to deny Ron Sims a license. Your Honors, we would argue also that the proceedings before the ALJ, before when Director Walsh...
If I can explore that. So you would define the pool of prospective plaintiffs, I guess now, to be Ron, And let's use Mendelssohn. What's the equivalent of the neighborhood?
It's literally putting a racetrack with gambling in a neighborhood.
So purely location-based. And let's say the record is crystal clear that the decision to license Ron will result in a $10,000 pecuniary injury or harm, or that's probably not the right word, to Jerry and the partnership. That, in your mind, is not sufficient to qualify for this pool of prospective challengers.
Judge Weinswig, if there was a finding in the record that said someone has lost money and here's the amount, could that party come and say their person's aggrieved? For example, a partner whose partner's the license was denied could say, hey, we have the right as a person aggrieved to appeal that decision as well because their person's aggrieved. But I go back to the statute which limits this issue. I think the statute prevails over the rule that said this is limited to parties.
The statute, and you're out of time, but which statute? You're talking about which statute?
Thank you, Your Honor. It's 41-1092.03B that the court has referenced, incorporated into 5104.
All right. Thank you very much, Mr. Tillemann, and let's go back now to Mr. Torrey.
Thank you, Your Honor. I'm going to be really quick. I think Ron doesn't genuinely believe 41-1092.03B applies. He never cited it to the commission. He never cited it in Superior Court. He never cited it in here. He knows it's inapplicable. Going to the intervention point, there was no reason for us to intervene at the notice of denial stage. At that point, there were no findings against us. It was only later when the director changed his decision and made these.
Isn't that the point of 1092.03B, though? You don't get to wait till the end and then comment. You have to make your comment so that you get the findings at the appropriate level?
No, not at all. Again, B is just a floor, and it just applies at the initial stage. And then there's a later.
You keep saying that, but you haven't convinced me yet. So let's assume that it isn't just a floor, that it is substantive and tells the commission who can apply. Did you comment below at all?
No, we did not comment below at all.
Okay, so there's no dispute as to that, whether you participated before you took it to the commission.
We commented to the director before the notice of denial. We did not comment at the ALJ stage.
Okay, so when your comment to the director, because that could be enough. I mean, it says, it just has to say that you commented. What was the form of your comment?
We provide.
Your Honor, I'd like to interject because I'd like the commission to have an opportunity to address.
Excuse me, whoever you are, you have to identify yourself.
Oh, this is Camila Alarcon, attorney for the Arizona Racing Commission.
Okay. Now hold on. Is the clock still going? Is this the same party?
No, we are a different party, but we are appellants, and we haven't had an opportunity.
Right. How much time is left?
2 seconds.
2 seconds.
All right. I'll give you 1 minute,
Okay.
Ms. Alarcon, and then I'm going to propose something.
Okay. All right. Thank you very much. I very, very much appreciate it. The way we thought about this issue was a little bit more of a holistic approach to all of Title 41 and the different agency statutes, along with the legislative history. So if you start at the beginning of Title 41, that applies to all agencies. It's like the big Arizona Procedures Act. The 1092 statutes, 1092.01 through .12 or so, apply to the Office of Administrative Hearing. Each agency oftentimes has its own statutes. And if you want to get into the realm of exhaustion of remedies, of administrative remedies, which is how I thought of this question that you posed, is that you start at the end, right? How do you get to Superior Court? And with racing, the only way you get to Superior Court is if you go through the commission. So if you go backwards, then with each agency having its own statutes, I completely agree that it's a procedural floor, and there are different agencies that have different processes for review, rehearing. They have, liquor has a different process of how you can appeal to the Arizona State Liquor Board. You have to do, like the Mendelson case, you have to be, which is still applicable today, you have to either own property or rent property within a mile radius. You could be a local
Counsel.
governing body. These are all
Counsel.
different. Yes, sorry.
Thank you. And I have to limit your time, but
Right.
let
Sorry.
me, and I'll hear from all of you briefly on accepting brief, if I can emphasize that, position of law on this statute, and which, if you do a word search, appears nowhere in what is a mountain of briefing. Is that something the parties would be amenable to? I'm not going to order it now, either page length or anything, but frankly, I see Judge Morse. I'll have to talk to my panel mates, but is that something that the three parties would be amenable to? Let me first hear from Mr. Torrey.
Yes, Your Honor, we would appreciate that opportunity.
Okay. Mr. Tillman?
Yes, Your Honor, if the court ordered it, we would be pleased to provide briefing.
All right. Now, Ms. Alarcon.
Yes.
Ms. Alarcon, I want to ask one quick question, and hopefully you can give me a 10-second answer, and if not, it will be covered in the briefing. Does the commission's position that the cross-reference in 5104D to all of 41-1092 only apply to the subsections that your other counsel had suggested, or is it intended to incorporate the entire statute?
It's our position that you have to harmonize all of the statutes.
Okay, thank you. So, yes, I agree. Judge Weinsweig, I agree with the need for additional briefing, and I think we should issue an order that would kind of direct the parties on length and timing. But I would hope that we would see a separate brief from the commission.
Yes, I was going to say that.
We will be filing a separate brief. Thank you.
Right. And, frankly, I might ask others to weigh in. Whether it's, the Attorney General but I'll think about possible amici as well. But, we have to get this right. Okay, well, with that, I have nothing else. I don't know if Judge Perkins' microphone is on. Judge Morse, do you have anything?
I do not. Thank you.
Okay. Well, let me thank you, all of you, for working with us in this difficult time. This is strange and awkward for us. Thank you for your excellent arguments, and we will take it further under advisement. We'll probably get something out on more briefing, and with that, we are adjourned.